Hello and welcome to BYJU'S IAS. Citizenship Amendment Bill 2019 has been passed by both houses of the Indian Parliament, signed by the President of India. So CAB is now an act of the Parliament, the law of the land. In this video, let us look at all that you need to know about the topic. But first up, what all are we going to cover in this video? We will be explaining some of the important terms, because without understanding these terms, it becomes difficult for you to understand the topic. We will be then looking at some of the provisions of the Indian Citizenship Act of 1955. Then we will be looking at the provisions of the CAB 2019, because CAB 2019 is basically an amendment to the Indian Citizenship Act of 1955. We will be looking at the arguments in favor of CAB, the arguments against CAB, what the critics have to say, and then we will look at this combine of CAB and NRC. So let's get started. But first up, let's look at all those who are residing within the territory of India, all the residents of India. All these residents of India can be broadly categorized into two categories. Either they are citizens or they are aliens. Aliens, basically foreigners. This concept of citizenship is basically a romance between the state and the citizens. It's also a symbiotic relationship where the state confers certain privileges, certain benefits, certain rights on the citizens. And in turn, citizens also have obligations, duties towards the state. Only the citizens have the right to vote. Only the citizens can contest elections. Only the citizens are eligible for government jobs. But if you look at fundamental rights, almost all the fundamental rights are available to both citizens as well as aliens, except 5 fundamental rights. Article 15, Article 16, Article 19, Article 29, and Article 30. Barring these 5 fundamental rights, all other fundamental rights are available both to citizens as well as aliens. But if you look at aliens, aliens can further be categorized into 2 broad categories. Either they are friendly aliens or they are enemy aliens. Who are these friendly aliens? Citizens of those countries which share good, healthy relationship with India. Who are enemy aliens? Citizens of those countries with which India is at war. But if you look at these aliens, foreigners, we can also call them migrants. This term, migrant, can further be categorized into 2 broad categories. Either a migrant is legal or the migrant is illegal. Now, who is a legal migrant? Let's say, for example, I am a citizen of Bangladesh. I want to enter into India for any purpose. Purpose can be educational, purpose can be hospitalization, purpose can be economic, purpose can be tourism. But I want to enter into India legally. What is the option for me? I approach the Indian embassy in Dhaka. I apply for a visa to enter into India. If this visa is provided to me, I enter into India. I am a legal migrant. But I can also be an illegal migrant. Now, who is an illegal migrant? There are 2 definitions for that. Definition number 1. I enter into India on a legal document, on a legal visa. But this visa was valid for a month or 2 months or 3 months. But what I'm doing, I'm overstaying in India. That means I am overstaying the period that is mentioned in the visa. I am an illegal migrant in India. Illegal migrant definition number 2. I enter into India, but without any visa, without any travel document. I sneak into India illegally. I am an illegal migrant. But some of these illegal migrants can also be referred to as refugees. The government of India can categorize some of these illegal migrants as refugees. That means they are illegally entering into India, they're illegally staying in India, but we are giving them a status of refugee. We will not deport them. But who is a refugee? According to United Nations, a refugee is someone who has been forced to flee his or her country because of persecution, because of war, because of violence. Let's say, for example, I am a refugee from Bangladesh. I have a well-founded fear that I will be persecuted in Bangladesh. Why? Because of my political opinions, because of my race, because of my religion. If I have a well-founded fear that I will face persecution in Bangladesh, I can enter into India even illegally, and then Government of India can confer a status of refugee on me. According to United Nations, two-thirds of the world refugees come from 5 countries only. Which are these 5 countries? Syria, Afghanistan, South Sudan, Myanmar, and Somalia. But now there is a convention, the 1951 Refugee Convention or Geneva Convention. This is the main international instrument of refugee law. This 1951 convention tells us who is a refugee, what are the benefits available to a refugee, what kind of legal protection is available to this refugee. This convention also talks about what are the obligations of this refugee in a country. This 1951 convention also tells us who is not eligible to be conferred with the status of a refugee. For example, a war criminal. War criminal is not eligible to be conferred with the status of a refugee. But if you look at this 1951 convention, the primary objective of this 1951 convention was to protect the European refugees in the aftermath of the Second World War. But then, few years later, in 1967, additional protocol was added to this 1951 convention, and now this 1951 refugee law and 1967 protocol deals with not only the European refugees, but refugees throughout the world. But important point, India has neither signed the 1951 Refugee Convention nor the additional protocol of the year 1967. If these concepts are clear, now let's jump to the discussion. Let's look at the Indian Citizenship Act of 1955. But first up, normally this matter citizenship is not mentioned in the Constitution. If you look at Constitution of almost all the countries of the world, citizenship is a matter that is left to a legislature, to the parliament to decide. But India is unique. Why? Because the country was partitioned, unfortunately on the grounds of religion. So in 1950, we had to be absolutely sure who are the Indian citizens, who are not the Indian citizens. That is why Part 2 of the Indian Constitution specifically deals with citizenship. If you look at Articles 5 to Article 11 of the Constitution of India, it deals with Part 2 of the Constitution of India. That means the provisions related to citizenship. But Article 11 becomes important for us. Article 11 gives unfractured power to the Parliament that you can regulate all matters related to this citizenship. That means Article 11 of the Constitution of India empowers the Parliament that you can frame a law, and through this law you can regulate all matters related to citizenship. Who can be an Indian citizen? What are the ways of acquiring Indian citizenship? How the Indian citizenship can be lost as well? And for this reason, the year was 1955 when Indian Citizenship Act was passed by the Indian Parliament. Now let's look at the ways in which an individual can acquire Indian citizenship. First way is by birth. Let's say, for example, a child is born today on the soil of India. This child is an Indian citizen provided if both the parents are Indians, or if one of the parent is an Indian and the other is not an illegal migrant. That means a child born today on the soil of India is an Indian citizen if either both the parents are Indians or one of the parent is an Indian and the other is not an illegal migrant. This child is an Indian citizen by birth. But what about descent? A child is born but not on the soil of India but outside, maybe in Germany. This child can also become an Indian citizen by descent, provided if both the parents are Indians or one of the parent is an Indian. That means a child born not on the soil of India but outside the territory of India, but one of the parent is an Indian, this child is an Indian by descent. Third way in which an individual can acquire Indian citizenship is by registration. One simple example, you are an Indian. Now you marry a German national or an Italian national. Your spouse can also become an Indian citizen by registration. For that, there are some conditions. Conditions, for example, this spouse should have stayed in India for a period of 7 years. That means your spouse, who is not an Indian, not born in India, not born to an Indian parent outside India, but is related to you by mechanism of marriage. One example, this spouse can also become an Indian citizen provided he or she applies for Indian citizenship by registration. For that, there are some conditions. That means the spouse should have stayed in India, should have resided in India for a period of 7 years. Fourth way in which an individual can acquire Indian citizenship is by acquisition of foreign territory. For example, Puducherry. It was a French colony. When India acquired Puducherry, the government was empowered to classify that all these people of the French colony are now Indian citizens. Why? Because we have acquired a foreign territory. And the fifth way in which you can acquire Indian citizenship is by naturalization. And what do we mean by naturalization? That means you're not born in India to an Indian parent. You're not born outside India to an Indian parent. You're not related to an Indian by a mechanism of marriage, for example. Your country has not been acquired by India. Even then you want to apply for Indian citizenship. You can do that through a process called naturalization. And there are some conditions which you have to satisfy. For example, if I want to apply for Indian citizenship, I have to give up my previous citizenship. I have to renounce my previous citizenship. I have to stay in India for a period of 14 years. And cumulatively, out of all these 14 years, for 11 years, I should have stayed in India. That means over the past 14 years, before you apply for Indian citizenship through naturalization, cumulatively, for 11 years, you should have stayed in India. There are some tough conditions on the basis of which you can be provided Indian citizenship by naturalization. But one common theme in all of this is you should not be an illegal migrant. If you are an illegal migrant, your children cannot become Indian citizens. If you are an illegal migrant, you cannot apply for Indian citizenship through registration, through naturalization, so on and so forth. That means illegal migrants were not eligible to apply for Indian citizenship. This is where we encounter two important terms. Jus soli, jus sanguinis. What is it? Law of the soil, law of the blood. Jus soli is something that is followed in United States. Jus sanguinis is something that is followed in India. That means in US, they follow law of the land. A child born on the soil of United States is a US citizen, regardless of the fact whether the parent is US national or not. Any child born on the soil of United States is a US citizen because they follow jus soli principle. But in India, no matter where you are born, but if you're linked to India through blood relations, you are an Indian citizen. That means we follow law of the blood, not law of the soil. Now let's come back to these illegal immigrants one more time. Illegal immigrants may be imprisoned or deported under the Foreigners Act of 1956 or the Passport Entry into India Act 1920. This Foreigners Act 1946, it regulates the entry and exit of foreigners into India. What is this Passport Entry into India Act? This act states that no foreigner can enter into India without a valid passport. But in 2015 and 2016, two notifications were issued by the central government. Because of these two notifications, what is the combined effect? The combined effect is that minorities from Pakistan, Afghanistan and Bangladesh. Which are these minorities? Hindus, Sikhs, Buddhists, Jains, Parsis and Christians. If they have entered into India illegally, that means they are illegal migrants, they have entered into India on or before December 31, 2014, they will not be subject to these two acts. If they are not subjected to these two acts, that means they will not be imprisoned, they will not be deported. This is the position of illegal migrants in India before CAB was implemented in this country. Now let's look at the provisions of CAB 2019. The provision is, what is the objective? The objective of this law is that there are people, minorities from three Islamic countries, Pakistan, Afghanistan, Bangladesh. They are facing religious persecution in these three countries. And if minorities are facing religious persecution in these three countries and they enter into India, who are these minorities? Hindus, Sikhs, Buddhists, Jains, Parsis and Christians. If these religious minorities in 3 Islamic countries, they have entered into India before or on 31st December 2014, they will not be treated as illegal migrants. When they will not be treated as illegal migrants, that means now they can apply for Indian citizenship, either through registration or through naturalization. That is one major provision of the CAB 2019. Two other provisions. Let's say, for example, there are illegal migrants. These illegal migrants are arrested, imprisoned, and their case is before the Foreigners Tribunal. That means Foreigners Tribunal would decide whether they are Indians or they are illegal migrants. If they are illegal migrants, we will deport them. Now, CAB 2019 states that all these religious minorities from 3 Islamic countries, they will be deemed as Indian citizens from the date they entered into India. That means this is going to be a retrospective law. That means this law will have a retrospective effect. That means these religious minorities who fled these countries because of religious persecution, they shall be deemed as Indian citizens from the date they entered into India. And on top of that, second provision, if their case is before a foreigners tribunal, all those cases will lapse. That means their cases which were pending before the foreigners tribunal, all these cases will abate. Now they will be deemed as Indian citizens from the date they entered into India. But the CAB 2019 also creates exceptions. Which are these exceptions? CAB will not apply to the tribal areas of Assam, Meghalaya, Mizoram and Tripura, because these 4 states have certain areas which come under Schedule 6 of the Constitution of India. That means if we are going to provide citizenship to these religious minorities from 3 Islamic countries, they will not be settled in the tribal areas which come under Schedule 6 of the Constitution of India. Now you might ask, why is Assam on boil? Why are people protesting in Assam? You need to understand that entire Assam is not under Schedule 6. There are few districts in Assam which are protected under Schedule 6 of the Constitution of India. Number 1. Another exception, there is something called Inner Line Permit, which was created by Bengal Eastern Frontier Regulation 1873. This is applicable in Mizoram, Arunachal Pradesh and Nagaland. Now the Home Minister says we are going to extend Inner Line Permit to Manipur as well. What is this Inner Line Permit? If there are Indians who want to enter into Arunachal Pradesh, Mizoram, Nagaland, they need a permission. They need a permit. Without this permit, they cannot enter into these areas. That means Indians from other parts of the country, if they want to enter into Arunachal Pradesh, Mizoram or Nagaland, they need a permission. That means CAB will also not be applicable to these ILP areas, and ILP is going to be extended to Manipur as well. That means all those illegal migrants who will be conferred Indian citizenship, they will also require permission to enter these areas. They will also require permit to enter these areas, but they will not be given permission to settle in these tribal areas. These are the exceptions that are created by the CAB 2019. Let's look at one more thing. I told you naturalization, that an individual can become Indian citizen through a process of naturalization as well. And what is this process? 14 years I should have stayed in India. But this 14-year period is calculated in such a manner that out of all these 14 years, for 11 years, you should have cumulatively stayed in India. Clear? Now this CAB 2019, specifically for the religious minorities from these 3 Islamic countries, this period of 11 years has now been reduced to 5 years. This is another important provision of CAB 2019. And something else regarding the cancellation of OCI registration. There is a card called Overseas Citizen of India card holder. If you were a citizen of India on 26 January 1950, but now you are a citizen of any other country, you can apply for OCI card. And if you have this OCI card, you can enter into India without any visa for life. That's what is the benefit of OCI card. But this OCI card could have been cancelled as well. On what grounds? There were 5 grounds mentioned on the basis of which this OCI card could have been cancelled. Ground number 1, if the registration was done through fraud. For example, Atish Tasir. He was a believer and follower of Prime Minister Modi, wrote extensively in his favor when Prime Minister Modi was running his campaign in 2014 Lok Sabha elections. But then he started criticizing Prime Minister Modi. And just before 2019 Lok Sabha election, he wrote an article in the Time magazine and referred to Prime Minister Modi as India's divider-in-chief. Atish Tasir had an OCI card because his mother was an Indian, noted writer Tavleen Singh. But his father was a Pakistani. The allegation is that he concealed this fact. He concealed the fact that his father was a Pakistani, and that is why if you have acquired this OCI card through fraud, your OCI card is cancelled. And that is how Atish Tasir's OCI card was cancelled. That means this OCI card can be cancelled if you have acquired this OCI card because of fraud. Second, if you show disaffection to the constitution, your OCI card can be cancelled. If you are engaging with the enemy country during the war, your OCI card can be cancelled. If it is in the interest of the sovereignty of India to cancel your OCI card can be cancelled. If within 5 years of your OCI card, if you have been subjected to a jail term of 2 years or more, your OCI card can be cancelled. Now, a sixth ground has been added by CAB 2019. If the OCI has violated any law that is in force in this country, not just these 5 grounds, if this OCI card holder violates any other law that is in force within the territory of India, this OCI card can be revoked, can be cancelled as well. But an opportunity will be provided to this OCI card holder before this OCI card is revoked or cancelled. These were some of the major provisions of the CAB 2019. Now, let's look at the arguments in favor of CAB. Argument number 1. This is a law to confer, not deprive citizenship. Why should people in India be worried about CAB? This CAB does not apply to Indian citizens right now. This CAB has primary motive of providing citizenship to those people, to those religious minorities from 3 Islamic countries who fled these countries because of religious persecution. That means this CAB has an objective of providing citizenship to religious minorities from 3 countries. It is not a law to deprive Indians of their citizenship. So we are only providing citizenship to other groups. We are not depriving Indians of their citizenship. So why are you criticizing this bill? Number 2 argument. There are people who say that this bill violates Article 14 of the Constitution of India, which talks about right to equality. If you look at Article 14 talks about 2 things: equality before law as well as equal protection of the laws. What is equality before law? No discrimination. That means there can be no discrimination whatsoever. But Article 14 also talks about equal protection of the laws. And equal protection of the laws basically means that you can't treat lion and the lamb equally. There has to be a special provision for lion, special provision for the lamb. Likes are to be treated alike. Unlikes cannot be treated in a similar fashion. And it is because of this equal protection of the laws that reservation is possible for SC, ST, OBCs in this country. It is because of this reason that children and women are provided special protection under Article 15 of the Constitution of India. So how is Article 14 violated? Now, this law is challenged before the Supreme Court. There is already a petition filed in the Supreme Court challenging the constitutional validity of this law. When this case will be heard by the Supreme Court will only look at it from 3 angles. Angle number 1, if Article 14 is violated, you have to prove it on 3 grounds. Ground number 1, what is the objective of this bill? The objective of this bill is that there are religious minorities from 3 countries, and in all these 3 countries, Islam is the state religion. And these minorities have faced religious persecution. So we are providing all these persecuted minorities citizenship. That is the objective of this bill. Second ground, intelligible differentia. That means you have to decide who is included, who is excluded. Who is excluded? Muslims from these 3 countries. Who all are included? All the minorities. Article 14 would have been violated If you would have said only Hindus or only Hindus and Sikhs from these three countries will be provided citizenship and you are excluding all other minorities, then Article 14 would have been violated, because you are not differentiating between those who are included, those who are excluded. This differentiate should be intelligible. That's ground number 2. Ground number 3, there should be a rational nexus. Rational nexus between those who are included and the objectives of this bill. Who all are included? Minorities from these three countries. What is the objective? The objective is to provide citizenship to these minorities. Problem solved. Article 14 is not violated. That means when we look at the arguments in favor of CAB, CAB is basically a law to confer citizenship. It is not a law to deprive citizenship. Even if it is challenged on the ground that Article 14 is violated, it will stand the test of judicial scrutiny. Why? When this challenge will be mounted before the Supreme Court will look at it whether Article 14 is violated or not. And it will look at this issue from 3 angles. Number 1, what is the statement of objects and reasons for this bill? To provide citizenship to religious minorities. For this very purpose, you are creating an intelligible differentiate. That means you are excluding someone, you are including someone. And third, the rational nexus. There has to be a nexus between who all are included and the objective of this bill. Problem solved. Article 14 is not violated. There is another ground on the basis of which this CAB is opposed, and that is the CAB violates secularism, which is part of the basic structure of the Indian Constitution. Why? Because you are excluding Muslims. But the point here is, Indian Muslims in no way are affected by CAB. Why? Because CAB is only a law to confer citizenship on others, not to deprive Indian Muslims of citizenship. If the objective of this bill would have been to deprive Indian Muslims of citizenship, then this bill would have violated secularism. But it clearly does not violate secularism. On top of that, what is secularism? Minorities should be protected. And if through this bill, you are protecting the minorities from 3 countries, then this bill basically strengthens secularism. It does not violate secularism. But then there are others who say, why do you include only Hindus, Christians, Sikhs, Parsis, Buddhists, for example? Why don't you include the Shias of Pakistan and Afghanistan, the Hazaras of Afghanistan? Why are you excluding them? Why are you excluding Ahmadiyas who are persecuted in Pakistan? Here you need to make a distinction between persecuted religious minorities and those who are persecuted because of their ethnicity. There are people who are criticizing this bill as to why are Sri Lankan Tamils not included in this bill. The reason here is, if Sri Lankan Tamils were included, if Ahmadiyas, Hazaras and Shias were included, then we would have clubbed those who faced ethnic persecution with those who faced religious persecution. That would not have been a reasonable classification. Reasonable classification, intelligible differentiate would say that all those who faced religious persecution should be clubbed. Religiously persecuted minorities cannot be clubbed with ethnically persecuted minorities. That is the intelligible differentiate. There are also those who criticize this bill on the grounds that this bill violates Article 15 of the Constitution of India and Article 21 of the Constitution of India. This bill does not violate Article 15 of the Constitution of India. Yes, Article 15 talks about non-discrimination, that the state cannot discriminate only on the grounds of religion, race, caste, sex, place of birth. The state cannot discriminate on the grounds of religion. Yes, but Article 15 applies only to citizens. It does not apply to foreigners. That means when Article 15 applies only to citizens and this bill talks about giving citizenship to foreigners, how Article 15 is violated? Clearly, the people from these 3 countries, the majority community from these 3 countries, they are not eligible for protection under Article 15 of the Constitution of India. Now, there are people who say that this bill violates Article 21 of the Constitution of India. It violates right to life and personal liberty, which the Supreme Court has said it also includes dignity of an individual. And because Article 21 is violated, that is why CAB is unconstitutional. But here is the argument. Article 21 applies to those who are in India. Article 21 does not apply to those who are coming from abroad. That means all those people in India, they will get the protection under Article 21 of the Constitution of India, not those who are coming from abroad. Clearly, this CAB does not violate Article 21 of the Constitution of India as well. And this bill also protects the tribal interests. As I told you that there are exceptions. Tribal areas under Schedule 6 of the Constitution of India, CAB would not apply. Those who come under inner line permit, CAB would not apply. So this law basically protects the tribal interest as well, protects Northeast as well. That is why the critics who criticize this bill are wrong. There are others also. If you look at the debate in both Lok Sabha as well as Rajya Sabha, some of the members of the parliament raised this objection that this bill should not be even introduced in the parliament. Why? They challenge something called legislative competence. The opposition says that Parliament has no legislative competence to even discuss this bill because this bill is unconstitutional. But that is far from reality. In fact, Article 11 gives unfractured power to the Parliament to regulate all matters related to citizenship. So if Parliament wants to frame a law, it is within the legislative competence of the Parliament. Let's go back to what B.R. Ambedkar had to say when the Constituent Assembly was debating the Constitution. Dr. Ambedkar said, it is not the object of this particular article, which is Article 5 of the Constitution of India, to lay down a permanent law of citizenship for the country. The business of laying down permanent law of citizenship has been left to the Parliament. So those who criticize that Parliament had no competence to even discuss this bill are wrong, because under Article 11 of the Constitution of India, it is the power of the Parliament to regulate all matters related to citizenship. But now, let's look at the arguments against CAB. But here I have a request. When I discuss the arguments in favor of CAB, some of you might have called me a Govt. But my only point is, I should provide you the arguments in favor as well. But now, when I will be discussing the arguments against CAB, don't call me a liberal, commie, liptard, so on and so forth. My only point is, dispassionately, without any bias, present before you both the arguments in favor as well as against CAB. Now let's look at the arguments against CAB. First up, religion-based classification. Religion cannot be the basis of citizenship in this country. Home Minister in his speech in the Parliament said that the importance of this bill lie in the fact that the country was partitioned on the grounds of religion. Half-truth. Pakistan was created in the name of religion, not India. India stayed secular. And how can in a secular country like India, religion be a basis for granting citizenship? That's argument number one. Argument number two, Article 14 is getting violated. How Article 14 is getting violated? I told you about the three tests. Test number one, statement of objects and reasons of this bill. Test number two, intelligible differentia. Test number three, rational nexus between the intelligible differentia and the reasons and the objects of the bill. Now, how Article 14 is getting violated? For that, let's go back to Anwar Ali Sarkar, 1942. In this case, the Supreme Court said that intelligible differentia means that there must be a yardstick to differentiate between those included in and those excluded as well. That was Anwar Ali Sarkar, 1952. Let's look at the recent judgment, Section 377 judgment, in which the Supreme Court decriminalized homosexuality. One of the judges on the bench, Justice Indu Malhotra, what she did, she welded, infused Article 15 into Article 14. Article 15 applies to citizens only. Article 15 says there can be no discrimination on the grounds of religion. What Justice Indu Malhotra did, she infused Article 15 into Article 14 as well. How? When under Article 14, you are creating intelligible differentia, Justice Indu Malhotra said that this intelligible differentia should also be reasonable. That means if there is a yardstick for some people to be included, some people to be excluded, this yardstick also should be reasonable. That means unless and until this yardstick is reasonable, you cannot discriminate. Justice Indu Malhotra further said, and this is where it becomes clear to you, that if on the basis of intrinsic trait of an individual, if on the basis of the core trait of an individual, you are discriminating, that is not a reasonable classification. And one of the core trait, one of the intrinsic trait is religion. That means religion cannot be basis for discrimination under Article 14 of the Constitution of India. That is why Article 14 is getting violated. But now let's look at all the criticisms one by one. First up, country-based classification. On what grounds have you chosen only three countries, Pakistan, Afghanistan and Bangladesh? Why is it that you have not chosen Sri Lanka? Why is it that you have not chosen Myanmar? Why is it that you have not chosen any other country? The government will have to convince the judiciary that while choosing these three countries, our classification was reasonable. If you look at the arguments of Harish Salve, one of the noted lawyers in this country, he says that it is the policy decision of the government. Government can pick and choose any country. Government can ignore any country as well. This is the policy decision of the government, and Supreme Court cannot question the policy of the government. But this is where I beg to differ with Honorable Harish Salve. If you recall, 122 2G licenses were cancelled by the Supreme Court. Why? Supreme Court said that you should not have followed first come first serve basis policy. You should have auctioned the spectrum. That was a matter of policy. But even on the matter of policy, Supreme Court said this is not something that you should have followed. All these 122 2G licenses should be cancelled. That means even in matters related to policy, Supreme Court can question the wisdom of the parliament. Supreme Court can question the wisdom of the executive. Point number one. Point number two, when the government will be asked to explain on what basis you chose these three countries and excluded others, because the classification has to be reasonable, argument number one that can be put forward by the government is that these are our neighbors. Pakistan, Afghanistan, Bangladesh is our neighbor. But neighbor is also Sri Lanka. Neighbor is also Myanmar. And we share a boundary with Myanmar as well. Why is it that you did not include Sri Lanka and Myanmar? On this ground, this bill will be declared unconstitutional. Argument number two put forward by the government, that we have chosen these countries because India was one, Pakistan was part of it, Bangladesh was part of it. If you have chosen countries who were part of undivided India, why are you choosing Afghanistan? Afghanistan was not part of undivided India. On this ground, it will be declared unconstitutional. Argument number third can be presented by the government, and that is degrees of harm. The government can try and convince the judiciary that if you look at the persecuted minorities in these three countries, Pakistan, Afghanistan and Bangladesh, the degrees of harm is more than any other country. That is why we have picked these three countries only. But here, why not Myanmar? 2013 report of the United Nations says the world's most persecuted minorities are the Rohingyas of Myanmar. Why did you not include the Rohingyas of Myanmar? If on the basis of degrees of harm, you have chosen these three countries? On this ground, the bill will be declared unconstitutional. Argument number four can be presented by the government. The classification might be limited to singling out persecuted religious minorities. If only religious minorities are to be included, why not Rohingyas, who are predominantly Muslims from Myanmar? Why not Sri Lanka? And if the argument is that in all these three countries, one particular religion is the state religion, which is Islam. In Sri Lanka, Buddhism is a state religion. In Myanmar, Buddhism is a state religion. And in both these countries, religious minorities have been persecuted. The Rohingyas and the Tamils. Tamils are persecuted not only because of their ethnicity, but because of their religion as well. And all these four grounds, which will be presented by the government before the judiciary, they do not stand the test of judicial scrutiny. CAB is unconstitutional. That's what critics say. That means critics say the manner in which the government has chosen these three countries is wrong. It is not reasonable classification. It violates Article 14 of the Constitution of India. Another criticism, there are people who say that this is just like Israeli law of return, where Israel's race laws determine that Israel is the natural home of all the Jews of the world. And through the CAB, you are trying to present as if India is the natural home for all the Hindus of the world. That is another argument presented by those who criticize this bill. They also criticize it on the grounds that why are Jews not included? Why are atheists ignored under this bill? That's another argument on the basis of which the critics attack CAB. Now let's look at Article 11 and CAB. Yes, Article 11 gives unfractured power to the Parliament to regulate all matters related to citizenship. There are critics who say that CAB violates the basic structure of Indian Constitution, which is secularism. Secularism is part of the basic structure of Indian Constitution. The proponents of this bill, those who favor this bill, say this basic structure doctrine only applies to amendment to the Constitution. That means no amendment to an Indian Constitution can violate the basic structure of Indian Constitution. That is why Keshavananda Bharati judgment of 1973 states. That means power of the Parliament to amend the Constitution is limited. Parliament cannot amend the Constitution and thereby violate the basic structure of Indian Constitution. CAB does not amend the Constitution. And that is why this doctrine of basic structure does not apply to CAB. But in numerous Supreme Court verdicts, Supreme Court has said not even an ordinary law can violate the basic structure of Indian Constitution. CAB is an ordinary law. Even this ordinary law under Article 11 of the Indian Constitution cannot violate the basic structure of Indian Constitution, which is secularism. That is why CAB is unconstitutional. Now let's look at another argument against CAB. This is where it becomes hilarious. Law and the lie. NRC was implemented in Assam. What is NRC? National Register of Citizens. This list contains the list of all the Indians. This was updated for the first time in 1951, but this year it was updated only for Assam. Why Assam? Because of Assam Accord of 1985, which was signed between the central government, the state of Assam, and the students of Assam. Why was Assam Accord signed? Because of the Assam agitation. What was the agitation? There was huge influx of migrants into Assam, and people in Assam feared that their language, their culture, their uniqueness, their distinctiveness is under threat. They have been swamped by the illegal migrants. There was a huge agitation from 1979 onwards. For close to 6 years, Assam Students Union, all Assam Students Union, other politicians, activists, they protested and they wanted Assam to be rid of these illegal migrants. Ultimately, the problem got resolved when Assam Accord was signed in 1985. And one of the features of the Assam Accord was all these illegal immigrants will be identified and they will be deported. That means Assam will be freed of illegal migrants. For that, the cutoff date was 25th March 1971. That means all those who have entered into Assam before this date, they will stay in Assam. But all those who have entered into Assam after this date, they will be identified and deported. Why this date? Because of Operation Searchlight, launched by Pakistan Army in East Pakistan, which is now Bangladesh. There was a war going on in Bangladesh, in East Pakistan. They wanted liberation of Bangladesh. And that is why lakhs and lakhs of Bangladeshis, they entered into India illegally because they were fleeing persecution at the hands of the Pakistani army in East Pakistan. And majority of them entered into Assam as well. So all those are to be identified and deported. That's what Assam Accord was all about. And now this NRC was implemented specifically for Assam. But when this NRC list was published, 19 million could not prove their Indian citizenship. And according to various reports, close to 5 to 6 lakhs were Bengali Hindus. That means they could not prove that they are the Indian citizens. That means NRC is basically an exercise to identify who are Indian citizens, who are illegal migrants. Those who are Indian citizens, their names will be mentioned in the NRC. And 19 million people in Assam were declared as non-citizens. That means they are illegal migrants. Out of them, 5 to 6 lakh people are Hindus. Now this CAB is going to protect them, and through this process, they will have to lie. How? when these 5 to 6 lakh Hindus, they submitted their papers for this NRC exercise, they claimed that they are Indians. They are not illegal migrants. Now, what the government is telling them, don't say you are Indians. Say that you are from Bangladesh, Pakistan, or Afghanistan, and we will give you Indian citizenship. That means through this law, the government is forcing these people to lie. And that's the hilarious part about the CAB. Now, there is another criticism of CAB. The objective of this bill is to protect and provide citizenship to persecuted minorities from 3 countries. But if you look at this bill, in the entire bill, there is no mention of religious persecution. If there is no mention of religious persecution, why are you taking into account only the religious minorities from 3 Islamic countries? That's another criticism. On top of that, there is another criticism. What is the criticism? The criticism is, let's say I am a man who entered into India illegally in 1971. I got married in India. I have kids. These kids are not eligible for Indian citizenship because one of their parent is an illegal migrant. Now, through this bill, you're saying that we want to protect those who are facing religious persecution in these 3 countries. How is my son or his son, how has he faced religious persecution? He was born in India. He remained in India. How did he face religious persecution? And it becomes very difficult to prove that they face religious persecution. That's another criticism of this bill. But important criticism is related to foreign policy. We have already witnessed that the Home Minister of Bangladesh cancelled his visit. The Foreign Minister of Bangladesh cancelled his visit because if you want to provide citizenship to those who have fled Bangladesh because they were facing religious persecution, that means you're attacking the Bangladeshi state. That means the CAB is going to affect the relationship between India and Bangladesh. And if you look at over the past few decades, India and Bangladesh have had stable relationship with each other. Because if you look at our neighborhood, Nepal was angry with us, Maldives was angry, Sri Lanka was angry, many other countries in our neighborhood were angry, but India and Bangladesh shared stable, friendly relationship with each other. And now that relationship is under strain because of CAB. Number 1. Number 2, the position of the government of India at United Nations and other world forums is that Pakistan is persecuting its own people. We take the example of Balochistan, that the Baloch people are facing persecution at the hands of the Pakistan army. When the question was asked to Home Minister Amit Shah, why is it that Ahmadiyas, why is it that Shias, why is it that Hazaras of Afghanistan, they are not included, they are not provided protection under CAB? His answer was, how can a Muslim be persecuted in an Islamic country? You prove to me that Muslims are persecuted in an Islamic country, I will give them citizenship. On one hand, at international forums, you are saying that Pakistan is persecuting its own people. And on the floor of the parliament, you are saying Muslims are not persecuted in Pakistan. It runs contrary to the position taken by India at global forums. That means tomorrow, when India will again raise the issue of Balochistan, the world leaders may not be sympathetic to that statement. That's another criticism of this bill. Also, the Hazaras of Afghanistan. It's almost certain that Taliban will come to power in Afghanistan. Taliban is in talks with United States. Taliban is in talks with the 5 permanent members of the United Nations Security Council. Taliban is also in talks with Pakistan. And all these countries, they are trying to bring stability in Afghanistan. And one way to bring stability in Afghanistan is to bring Taliban on the negotiating table. So in all likelihood, Taliban will be part of the next government in Afghanistan. But Taliban has persecuted the Hazaras of Afghanistan. Hazaras are Muslims. So these Hazaras would have been the asset, would have been the diplomatic asset of India while dealing with Taliban. Now you are depriving these Hazaras of Indian protection as well. So why would they take the side of India against Taliban? That means the CAB, according to some critics, has committed historic foreign policy blunders as well. Another criticism, I told you that a 6th ground has been added on the basis of which your OCI card can be cancelled. And what is that 6th ground? If you violate any law that is forced in this country, motor vehicles law. That means if you are not driving with a proper license, your OCI card can be cancelled. This is very unreasonable. You should have clearly mentioned which laws an OCI card holder should not violate. And if you violate those laws, your OCI card will be cancelled. Unreasonable. Also, if you look at the debate on this Citizenship Amendment Bill in both houses of the Indian Parliament, one pact was referred to frequently, and that was the Nehru-Liaquat Pact. It can be a question in your prelims. What is this Nehru-Liaquat Pact signed between the Prime Ministers of India and Pakistan? This act was signed in Delhi in 1950. That is why it is called as Delhi Pact as well. The objective of this pact was to provide a framework for the treatment of minorities in two countries. The pact was that minorities should not be deprived of their rights in both the countries. Minorities will be protected in both the countries. Minorities' rights will be safeguarded in both the countries. The manner in which they want to practice, profess and propagate their religion will be protected. According to this pact, members of the minorities shall have equal opportunity with the members of the majority community. That's the brief about Delhi Pact of 1950 or Nehru-Liaquat Pact. Now let's look at the combine of NRC and CAB. When NRC was implemented in Assam, according to reports, 5 to 6 lakh Bengali Hindus were excluded from NRC. Government wanted to protect them, provide them citizenship. That is why they brought in a law primarily to provide citizenship to 5 to 6 lakh Bengali Hindus. But now Home Minister has reiterated many a times, even inside Parliament, that we are going to implement a nationwide NRC. That means if we look at this deadly combo of NRC and CAB, CAB says Muslims from other countries cannot become Indian citizens. NRC, Indian Muslims will have to prove their citizenship. That is the combined effect of NRC and CAB. That is why some people say if you look at CAB in isolation, there is no harm, there is no problem with this law. But when you combine CAB with NRC, this is a deadly weapon to disenfranchise Indian Muslims. That is all that you need to know from this topic. Thank you for being with us. Have a great day.